Hello, and welcome to today's Planning with Purpose course. I'm Michelle. I'm your host for the course as well as for today's class. If this is your first time attending, please make sure to check out our YouTube channel and get caught up on our prior courses, on all the other courses. And it can be really helpful because the way that I've structured the course is that we tend to stack this additional information that we're working on from month to month on top of those items that we've already covered. And we tend to pull information from we tend to pull some of that information to work on some of the stuff that we're doing in some of these further courses. A funny story. I know we mentioned before, like a lot of times when we're working on trying to create something like this or implement something like this for our financial life, it tends to be so overwhelming. We're not really sure where to start and we often lose momentum. And I totally get that. In fact, this last week, Brittany and I were in Austin for a conference. And one of the evenings we had a vendor that was going to be taking us to a meal. And we decided that, being in Austin, we had to ride the scooters that are like literally all over the place. And we pulled it up to see the best route to go. And if you've been in downtown Austin where we were, it was, traffic at that between 5 and really between any time, but usually around 5 o'clock is going to be rather congested. So we decided to take the scooters and we could do it on the bike trail. And we were able to ride the scooters on the bike trail and we wouldn't be in the middle of traffic. And so it said it was going to be like a 7-minute ride. And we were super excited, did our little Bird app, got on the scooter, made our way down, and about maybe a quarter way into the trail, our scooters just shut off. We had no idea, nor did the app show that this was a non-operational zone. You could ride the bikes along that way and there was no problem, but apparently the scooters were non-operational zoned in that area. And not only did it not, like it just stopped moving, we had to push it. We couldn't even shut it off. It was considered a no ride, no park zone as well. So we had to push it a distance, a pretty decent distance. And then it would beep and we could hop on and ride it a short distance and then it would beep and then it would shut down. And so we did this. Our 7-minute ride ended up taking close to like 40 minutes to get there. And I think that if we were able to park it at one point, we would have. I mean, like we totally were, it was definitely non-operational. But since we weren't able to park it, then we kind of had to, we were committed at that point. But I think that often happens with us when we work on something like our financial, gathering our financial or organizing our financial life, is because we get into one of those non-operational zones. It just becomes so overwhelming and we're just like, let's park it and walk away. And so the goal that we came up with here for this class is to create a structured, easy to update. And the easy to update is really important because you don't want to have to start from the beginning. And a lot of times if we're doing it in paper format or a nice little notebook, that we're going to have to start over. It's not, scratching out things and just making little notes alongside is not that easy to do. It's definitely not the best for those that you're leaving behind. So we want something that is a structured, easy to update, and shareable system of your entire financial life. And it's going to include things like your accounts, which are not only just your banking and investment accounts, but your expenses as well. What bills do you have? What systems are you on subscription services? Who do you use for your electric provider? I think it was our second class, we looked at, there's 130 different choices around. So it's important to kind of list those out and make it easier for our loved ones that we leave behind. Also leaving behind our passwords and login credentials, any type of valuable information, creating a home inventory, account titlings, estate documents, and those help to ensure we have everything lined up now correctly, but also not only just for now, but also for the loved ones that we leave behind. Now, this month for June, we're going to be discussing, it really revolves around debt. And it's looking at like what you owe, organizing your debt, and how to get things paid. And these classes, I think if you were in it last, and it was just about 2 weeks ago because I had to postpone, they're hitting a little close to home right now because I lost my dad just under a month ago. And so many of the things that we're discussing, I'm like right in the middle of the weeds with right now. And so I know that some of this stuff that we're covering actually works because it's been a little like almost eerily easy on some of this stuff that we've gone through. Like I said, he left like a binder of stuff. And so it has a lot of this information in it for me. And so it does make it a little easier than just having to, to shoot in the dark with a lot of this. So the first thing we wanted to look at was your organizing your debt. And I think kind of separating some of the things out between secured and unsecured is some of the easiest way to do it initially. And making sure that any of the secured debt that you have, is there anything that you're going to be passing along? And if there is, if we're looking at a vehicle or a deed for a house, anything like that, are those titles and deeds aligned with how you want that property to be transferred? Not necessarily changing those titles now, but is it structured in a way, or is it established in a way that will make it easier? And what I mean by that is like for spouses, should the spouse be listed on a vehicle title as a joint with right of survivorship? Because they can be listed as a joint on that, but there's also a survivorship listing or a right of survivorship listing on that will then automatically pass that. And we looked at this, and I think it was last month or the month before, about how those rights of survivorship or payable on death and transfer on death, any of those contract law types of things, basically leaving it as a beneficiary can help bypass some of the probate process. That all it takes is the death certificate and it will automatically pass. That's a good thing in some ways for something like this, to where it won't have to go through probate. And we saw the negativity that it can cause if you're wanting to maybe include that, like if you added a child to a checking account or savings account, and your intent was to actually have that be distributed amongst all of your children. I think we use the example of if you had a son and a daughter, and dad passes and mom adds daughter to the account with the intention of those funds, passing equally to her son and daughter 50-50 upon her death. By adding daughter on that checking account to make sure she can, pay bills in her incapacitation, then we've now removed that pot of money from the will, and that will pass outside of the probate process, leaving zero of that to the other or to the son. And so that could be a good thing in a situation like this, is if that's what your intention is. But we just want to make sure that that is what you intend to do with it. And if it is, it's a great way. Contract law works really well in something like that. So spouses can do if we're looking at a car title or a vehicle title, I think it's a form VTR 122. You can pull up on the Texas site. Just Google Texas title VTR 122. It has where you can do that, add that on there, the right of survivorship. In fact, I think if it's a spouse, it doesn't even require a notary signature. You can just keep it in your file with the title that you have. If it's a non-spouse, it will require a notary, but very easy. Local bank or credit union can do that for you. We're looking at not just car titles, but anything that has a title, whether it's motorcycle, boat, RV, anything that would have a title. Look at if that's something you want to pass through contract law. House as well. Now, a lot of times, you may not want to pass that. You may want to pass it now, like with a spouse, that's fine. You may want to add them on as a joint with right of survivorship. Oftentimes you don't want to add certain people on as a joint owner. And that's because transferring ownership while alive, even adding them on as a joint, may hinder any type of step up in cost basis you'll receive or that they would receive upon death. And that's because upon death, whatever that asset is valued at on the date of death, you get the step up in that basis. So let's say, for instance, you have a house, and let's say that you paid, let's say you bought it a long time ago and you paid $50,000 for it, and now it's worth $250,000. Well, if you had sold that, or if you had given it to someone, that would have been a $200,000 gift, right? Because that's the capital gains that it has earned. And so it's now worth $200,000 more than what you bought it for. So that's a gift. However, if they inherit it, it's like they paid $250,000. So if they go to sell it and it's worth $1 million later, they don't have to claim that $50,000 and pay the gains on that full amount. They can say, oh, well, I paid $250 for it. Now it's worth $1 million. Now I can just claim that $750. So it does have its benefits. So how you title your deeds and or how you have listed on the names listed on your deeds and your titles is really important, whether you want it to pass by contract law or transfer in some way like that. That is something to look at. A lot of people will set that up to go into a trust, and that's an option as well. We see quite a few that opt to put items into a trust, whether it be their house, and they may have different reasons, not just to avoid probate. There are some other reasons to transfer property into a trust. So I wouldn't do that necessarily just to avoid probate. Probate is really easy in Texas. Texas is a fairly easy state to die in. Not every state is, but Texas is. The next thing we wanted to touch on was getting your bills in order. And we kind of did this when we looked at establishing like your passwords and usernames and accounts and all of that in class 2. But we want to make sure that we provide that list to whoever and make sure that it's actually current, and provide information now on not just how to access that, but how to cancel that as well. What contact information? Let's expand that a little bit. Is there a customer service number? Is there a certain person you work with? A lot of times we may have someone that we talk with personally at a bank or a credit union that we can reach out to that kind of handles our stuff. Would it be easier for our loved ones to reach out to that specific person? And if that's the case, then list that down on this, this matrix that you're making for them. So we're going to list, all of those passwords and usernames and accounts that we have, that we've already created, and then make a list of those recurring bills along with the frequencies, provide the contact information of how to contact or how to cancel any of those types of things as well. And also how to get some things paid once we die. This is probably the one we're going to be touching on the most today, because this is one of the biggest issues. How do we pay for things, or how do we, I guess we won't care because we're not around any longer, but how is our family going to pay for certain things once we're deceased? And depending on how things are structured and titled and situated, that's going to make a huge difference in this. If you have an account that is a joint with right of survivorship, or a POD or TOD, something that's titled by contract law or survivorship types of account titlings, those are out of the way. Those can technically go to whoever that's listed on that account, and you may not have access to them. And so if, let's say, for instance, in the example we used last month and we kind of touched on today, let's say that you have son and daughter and mom passes, and daughter's on that checking account to pay the bills, but yet son is executor on the will, well, daughter may take that whole checking account, and what is son going to pay those bills with? Because this can go out. It's not part of the estate. So she can show a death certificate and that's gone. So what is he going to use to pay the estate, the electricity and the water bill and all those types of things until something can be done with the property? And so those are things that you want to look at to make sure that things are set up properly. Yes, we know that we can liquidate certain things, but it could take a while before life insurance proceeds are available. It could take a while before IRAs are available to transfer over. It could take a while before there's access to certain things, and obviously before the probate proceeds are available. Typically, yes, depending on how the will is written, it may provide the executor to start selling or liquidating certain things to pay for other things. Like I can liquidate certain things in the house that I know I can kind of get rid of quickly to continue to pay the mortgage payment so it doesn't go in default, or pay the electric bill, or do typically what if you contact the electric company or the water company and places like that, and for that matter, the mortgage company, there's usually some form of grace period that they'll provide on that, because they know that it's going to take some time, and it's up to the court on how long some of that time takes and how quickly can you get the death certificates. It took us I got them just yesterday, and it was almost a month. So we were kind of at a standstill until we got those in. And we're going to be even at a longer standstill because it could take weeks before we can get into court after, once we file that application for probate. So it's not a quick process. So having some cash or a pot of something set aside that you can access to pay those bills. Credit cards are really good. A lot of times, though, a bank finding out that you're deceased, and believe me, they do look through the obits, they may shut down that limit. They may, they may not have that limit available for them anymore if it's just that one individual that's listed on that credit card. So it's important to set up or have some alternative methods. It's also important to, even if they don't shut off the limit, watch for those limits. You're going to have to make payments. You don't want to hit the limit, go over the limit, get charged with fees. You want to also make sure there's not any fraudulent activity on the account. So you're going to need to have some type of login credentials to monitor those charges and to check the expenses and to make payments on. And so it's important to have those, like we talked about in class 2, those login credentials, so you can go in and check those types of things. Now, how do we get some other bigger things paid, like the mortgage? And this is one that is a little touchy, and I've been questioned about it a number of times, and I really didn't know much or really how to answer that until we did a little bit of research. And because usually what happens is once someone passes, then if you're going to assume, let's say that I have a car loan, and if I pass and I want to, in my will even, I say that, someone gets my car, that I would like for them to have it. And because I may have a good amount of equity in it, then they can then take over that loan. They can finance, get a loan in their name and then pay off that loan. And then the car is now theirs. And so that makes it rather easy. But what if they don't qualify? Well, for a vehicle loan, that's going to make it a bit difficult because there's really no other protection there. I mean, you could use some of the insurance money. You may be able to get, from some other pool of money. If there's any type of retirement assets you can pull from. But for a mortgage, that's kind of a bigger thing. I mean, a car loan is, usually not such a large dollar amount, but a mortgage is. Typically that's a much bigger, a bigger balance. And so And there's often what we call, and a lot of loans have this, what they call a due on sale clause. And it requires a loan to be paid in full when we're changing the name or retitling that title or the deed. And that becomes really difficult if, let's say you have a widow and the house was in just the husband's name. And that was not uncommon back years ago with like my grandparents, that my grandpa worked and my grandma stayed home and all the loans were in his name. There wasn't like joint, names on the account. I mean, they were joint names listed on the checking and savings account that she was a signatory on the credit card, but like the house wasn't in both names. We had to literally get that house quick deeded over to have it in her name. So a lot of this stuff made it really difficult years ago that, like, how do you do that? Like if there's still a mortgage on it, even though the wife or the widow could continue to make that payment with the insurance funds or pension or what, Social Security or whatever else income she may have coming in. If the bank said, nope, you got to pay it all right now, or you have to qualify for another loan, and she has zero like earned income on that, it can make it quite difficult. And so in 1982, there was a federal law that was passed, and it was called let me make sure I get this right. And I touched on this in the last month's class as well. So if you want to go back and look at that, we kind of dug into it a little bit on that one. It was called the Garn-St. Germain Depository Institutions Act. And what this did is it prohibited the enforcement of that due on sale clause after specific kinds of transactions like property transfer to a relative upon the borrower's death or transfer of property from a parent to a child. So if the property transfer is covered under that Garn-St. Germain Act, you can keep making payments on that loan. And then the transfer can't be the basis for an acceleration of the loan due or for foreclosure. And you can actually assume the loan if you want. And the Consumer Financial Protection Bureau, we're going to call it CFPB, issued the interpretive rule that helps an heir assume a debt's mortgage after inheriting the home. And specifically what it does is it says that after the original borrower dies, the person who inherits the home may be added to the loan as the borrower without triggering the ability to repay, which is the ATR rule. And they are listed as a successor in interest, and they get these exact same protections under the federal mortgage servicing laws as the original borrower does. And that's important because if you need to call to make a change to the loan, like if something happens and you have a hail damage to your house or to your roof, and you have to send in that check and it's made payable to, the original borrower and the mortgage company, how are you going to do that? So it was important that they make it payable, and the insurance company can do this as well, but it was important that they sign it over to you as well, or they apply anything that they would be able to provide to the original owner to you. And so same laws are in effect as it would be if you were the original borrower. So that was a really neat rule that came out. Now, the successor in interest, I mentioned, gets the same protection, but who qualifies for that? And they said the interpretive rule was a transfer by device, like a will, or an operation of law on the death of a joint, which is what we've talked about, contract law. And that's by joint with right of survivorship, transfer on death, payable on death, something like that. Transfer to a relative after the death of a borrower. And so kind of under that same rule, and maybe just not by will, but maybe the executor has chosen that this is how we're devising property. Like this, they can kind of substitute property within the will, like, okay, you're getting this amount, but we're going to substitute the property. That could be kind of in the same thing. Even though it doesn't specifically list that person, the executor can substitute that property. So that's kind of what that does after death. Transfer where the spouse or child of the borrower becomes the owner of the property. I can transfer that house to my child and it not trigger that due on sale clause, and they can then be listed as the successor in interest, or on the resulting in a decree of dissolution of a marriage, legal separation agreement, or incidental property settlement agreement by which the spouse or borrower becomes the owner of the property. And so that any of those that are like transferring internally like that between family members can qualify for that. Now, as I mentioned, other property like vehicles do not qualify for this. It's only they do not fall under the exclusion of the due on sale clause. Only the mortgage does. So they can add the due on sale can totally be enforced on that. And that's even if survivorship is listed on the title. So if I listed a right of survivorship on my title, and it can go to that person, but they're still responsible for that debt. So lots of stuff to consider when you're looking at your estate planning documents. When we looked at those last month, we wanted to kind of get the idea and start mapping those things out. And one of the things that I suggested was like virtually kill yourself right now on paper and see how that property is going to pass. What is going to happen? What insurance policies are going to flow through? How are the checking accounts and savings accounts going to be paid out? How are the IRAs going to flow to those beneficiaries, and make sure there are no hiccups? And it's important to do it on this as well, not just with the assets that you have, but how is this debt going to be paid too? And see if there are any hiccups along the way that can be headed off now, and kind of get those into your estate plan to make sure before you finalize anything, to make sure that those are not problematic after your death. So I think our next class we're going to be talking about medical wishes, advance directives, and organ donation. And that's going to be on July 6th. And we hope to see you back then. Again, I will send out a link that you can register. Registration is free to attend, but registration is required. Share the link and invite as many of your friends and family as you want. It is free for them as well. And we make sure if you've missed any of the classes, or if you just want a refresher, hit our YouTube channel and check those out again. So until next time, take care.